Go ahead. You state your name, please.
Good morning, Your Honor. Pamela Peel.
All right. Miss Gerler, are you there?
Yes, I am, Your Honor. I am present. Thank you.
Okay. Can you state your name for the record, please?
Nancy Rose Gerber.
Thank you. All right. Have you seen? All right. Have you two talked at all in terms of resolving this, or where are we on that?
No, we have not.
How much is your claim?
I'm requesting a money judgment of $12,406, which includes unpaid rent of $12,950,
12,900.
out-of-pocket court costs.
Hang on. Give me the rent again.
Oh, yeah. $12,950.
Okay.
Which is on the balance statement that I gave Nancy Rose. Out-of-pocket court expenses, $215, court serving fee, $68. And then after we inspected the house and stuff, I added cleaning fees of 5 hours at $20 an hour, 2 extra days rent at $34 a day. And to the amount of that totals $13,401.
$13,401.
I then deducted the security deposit that she had
Okay, which was how
for
much?
$995, and
How much?
it's up to $12,000.
How much was the security?
$995.
All right, and then that's how you get to the 12,406.
Yeah.
Okay, so out of the gate, you're going to have to add $2.55 because the service fee, as the court has it, is $70.55, not $68.
Oh, okay. Oh, I thought it was
The
okay.
What's also going to come off of the total amount is going to be the 5 hours of cleaning.
Pardon?
The 5 hours of cleaning. So the $100 that you put on for cleaning also it needs to be deducted.
From the security deposit? Or
I probably don't want to do it that way, but it's going to have to be deducted off of your total.
Oh, okay, so I can't do that.
Can't do that.
Okay. All right. That's
that way. And then the 2 days of rent, that was for what?
Nancy Rose was unable to move out on the 31st as the judgment requested, and she stayed till midnight, February 2nd.
Ms. Gerler, do you agree with that or no?
No, Your Honor. I do have some comments regarding what.
Well, I understand you have comments. I'm dealing with just this issue. Were you there the 2 days beyond the 31st?
I was there the 2 days beyond the 31st. It was my understanding I had up to 10 days to vacate, and did not believe that there would be an additional sum for those 2 days, which were spent cleaning, and professional cleaner did clean the house on
Okay, it's fine. I'm dealing with this one by one. And so I'm just telling you, you're saying you did occupy the unit those 2 days.
Yes,
for whatever the reason. Okay.
Yes, you're
all right. Now I'm going to ask a general question, Ms. Gerler, and I need not a highly specific answer, but just this. Of the $12,406, is there any amount of that you believe you owe?
Your Honor, what was in contest at our last hearing was my stated concern that I had enlisted the help of Miss Biles at Faith in Action, and we could have been brought current at the first problem, and it was just shy of
Gerler, Miss
$3,000.
Gerler,
Sir, I just
listen
want to,
listen very closely to my question. Of the $12,406, which is primarily consisting of rent, is there any amount you believe that you owe or admit that you owe of that amount of rent?
sir, if we were able to subtract the 3,000 she might have gotten, yes, then I would say that I am responsible for the balance.
So what your claim is, and is that if the 3,000 had been paid by the outside agencies, what you would owe at this time would be the $9,406,
If that is the
right?
balance, Your Honor, yes.
Okay.
When I talked to when Faith in Action approached me, they offered $800
How much?
1 month. And nothing was
They offered
right.
what?
They offered 800 toward her rent for
Right.
1
What
month. That's all
I
I knew about.
understand, but what I'm getting at is, and I think what Ms. Gerler's getting at is, had Faith in Action plus what would have been the other agencies of Hawk and the like, she would have gotten a maximum of 3,000. I think that's what she stated the last time. That's what she continues to state at this time.
Okay.
All right. So
And
while she's pointing to one agency, I understand what Ms. Gerler's indicating, that there's this other agency.
May I respond to that?
To which?
To the $3,000
I
offer
don't,
that I
okay, first of all, here's the problem, ladies. You're fighting over stuff that doesn't make sense to me right now. Okay? And let me tell you why. Ms. Gerler admits she would owe the 9,406 in essence, and I appreciate her candor on that. There's now going to be argument over this 3,000 that Ms. Gerler says, because you're saying that they're only going to pay 8. I get where Ms. Gerler's coming from because what I just said. Here's the problem with all of that. The problem with all of that is there would have been no payment with these programs if the tenancy wasn't going to be maintained. So the 3,000 wouldn't have come in. But I understand Ms. Gerler's point that, okay, it may have come down to this point, but if you had taken that money at this point, then I'd be 3,000 to the good, basically, is what she's indicating. All right. So let me just.
I never got anything in writing to that effect. And they never said that to me over the phone. I didn't know about Hawk. I didn't know about any of them.
Okay. I get that.
Okay.
What are you guys really fighting over?
I just want to be paid the rent that I'm owed.
Okay.
And that she promised to pay
Okay.
each month.
And Ms. Gerler?
Yes, Your Honor.
Are you working?
Not at present, Your Honor.
All right. And so
I only have Social Security income.
that's what I thought. You have Social Security.
Yes.
The SSD or SSI? Which one?
SSI, sir.
I can sit here through a trial. You can put on your proofs. You can do whatever. She's admitting basically to almost 3/4 of what you're saying anyway, right? Because if she's admitting to the 9,400, the 3,000 may be a question, but I've said what I've said. But here's the bottom line, and why I'm trying to figure out entirely why we're here. And let me just, and I'm going to do this just in terms of the practicalities of it. All right. We can go through the trial, and I don't mind. You guys have my time. I can sit here through the trial. The cold-hearted reality of it is Miss Teagle, you come down to the end, and let's say, just by hypothetically, and I'm not saying this is the way I'm finding, I find entirely in your favor, and I give you that judgment for the 12,000 plus. Let's just say I do that. how do you intend to get that money?
Your Honor, it was a matter of principle.
Okay, I understand.
Per-
There are principles all over the place, and people can fight on principle or whatever. My question is how would you intend on getting that paid? You told me you want the money. I get it. But how are you going to get that?
Well, I don't know, but I also make about the same amount of money in Social Security as Nancy Rose does, and that income was I depended on, and I worked hard, and
Man,
I
I
did put money aside.
appreciate all of that.
Okay, just one.
I'm just
say
getting
no.
no, I know.
I'm not
I'm
rich.
not I'm not saying that you
Yeah.
are. The reason I asked about her income is because that's where any judgment you would get would come from. Right? But but you can't garnish her SSI until potentially at least there's an argument that it would be transformed into something else. If that's indeed all her income, go ahead.
Well, I know Nancy Rose is a psychic, and she does a lot of readings in the past, and it's not always, above board. So she does have other income, which I
Okay.
to bring that up.
So okay. What do you want me to do? Do you want me to give you a judgment for the full amount?
I don't ever expect. I mean, she gave me her word that
Okay,
she would
I
pay.
asked a question.
don't
How come nobody
expect-
just answers my question? Do you want a judgment for the full amount?
I
We want to
do.
sit here through a trial? I mean, if that's what you want to do, let's do it. I mean, I'm trying to just give both of you the practical realities of it. That's all I'm trying to do. But if you want to sit here and we just go through the time of doing it, that's why I'm here. Let's do it. Mr. Allen, swear her in. I mean, it makes no sense to me. It's a waste.
Really?
It becomes a waste of time that you two can't resolve this.
May I speak to my husband for 1 second?
You want to speak to
My husband?
your husband? Go for it.
All
Go
right.
ahead. Talk to him. Go ahead. I'm going to stand in brief recess. I'm going to step out for a moment. All right. Ms. Gerler will be right back. Okay.
Thank you very much, Your Honor.
Thank you. Court's in recess. We call the case of
My husband talks.
P.O. versus Gessler.
Well, my husband.
Hold on a
talks to
second.
his sons.
Miss
Sorry.
Gerler? I'm not Mr. Gessler. Miss Gerler, are you there?
Yes, sir, I'm here. We just
Okay,
had
there
to
you are.
technically
All right.
handle it. Thank you.
All right.
I will accept the $3,000 that you're proposing.
The 3,000 deduction.
Yes.
Okay. Ms. Gerler, did you understand what plaintiff was indicating?
Yes, Your Honor, and that is a satisfactory conclusion. Thank you.
All right. So I'm going to enter a judgment total amount. So here's what I'm going to do.
Your Honor?
No, that's not right. Hang on one moment.
Okay.
I have rent. Let me just go through the figures so that we're all clear on everything. So I'm going to have a total rental amount of $12,950. But
Your Honor,
where
that's
I'm
not
gonna, but hold on a second. Hold on a second. Where I'm going to take the rental amount off, the 3,000 off, is I'm going to take it off of that figure.
Your Honor, the rent figure given is not accurate.
Which part is not accurate?
The rent itself did not come to 12,900. Should be 11,900 and the change, not 12,000. That's adding another month's rent that was not applicable because she received the security deposit for that.
Well, no, I haven't gotten to that deduction yet.
Oh, I'm sorry, sir.
Okay. So just let me get through the figures, and then if anybody has a dispute, given what you've said, then we'll do it that way.
I thought it was $10,301.
Hold on. No. Everybody just stay with me in my math, okay? I took the 12,950, took off the 3,000 we talked about. That brings me to $9,950.
Mhm.
You're also claiming $68 of rent.
Okay.
That brings the figure back up to $10,018.
Okay. Then the court fees?
Ma'am, please. Without talking, just let me get through it and then we can back it off. Then I'm going to subtract out the security deposit, which was how much?
$995.
That's right, Miss Gerler. It was $995, correct?
That is correct, sir.
All right. So then, Emily, help me. I come to 9023.
Sounds good.
Okay. That then is the total judgment amount. And now I'm going to add the cost in. And the costs that are added in that the court has is $215 plus $70.55 service fee for $285.55. Add those costs in, I come up with $9,308.55. That is the judgment amount and how I figured it. To the plaintiff, that figure is acceptable to you?
Yes, it is.
Ms. Gerler, is that acceptable to you?
Yes, it is, Your Honor.
Wonderful. All right. So what I'm going to need, yes, ma'am.
May I ask Nancy how she intends to pay that? Or if she, and what time frame can I expect?
Well, let me do it this way. Ma'am, did you want to enter into a payment plan at this point? Or do you want the judgment to enter and then you can file for, she could try to collect and then you file for, come back, and then I have to decide what the payment is? How do you want to do that?
Your Honor, there's no commitment that I can make at this time. I am not working. I have lost all the phone numbers affiliated with my business. I have had chronic problems with chronic illness and even finding a permanent place to live. I
Got it.
certainly hope
Okay.
this changes in the future, and I will make every effort to pay towards, but at this point I can make no commitments because I literally do not have it, nor secure or stable additions to the Social Security income that I get.
Got it. So what that means is that you're left to the
Okay,
collection procedures that
All
you
right.
can.
that's
The
fine.
court will enter a judgment. Judgment amount of $9,023. Cost of $285.55 for a total amount of $9,308.55. All right.
Thank you.
You'll need to fill out a money judgment form out at the counter. And then once I get it, I'll sign off.
We have with Courtney Waldick. Judge, this is date time set for our second probable cause conference. At this time, Ms. Waldick is inclined to waive her right to preliminary exam, and we've gone over those rights.
Well, is that correct? You're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
And you understand that you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor, we do, and again, that's the date I'd like to address on the appropriate time.
Pardon?
Yes, I do waive, but in case this affects her pretrial date, I'd like to address bond if you have.
All right. So before I set the date, you may address bonds. Go ahead.
Your Honor, at the time my office charged this case, we requested a 100,000 cash surety bond. At this time, I am renewing that request. I understand that Ms. Waldick was given a 50,000, 10% bond at the time of her arraignment. When we were last before Your Honor, I did not have the benefit of certainly I still don't have the report because the investigation continues to be ongoing. However, the information that is now available to me has grown substantially since we were last here. I will start off by going through essentially the timeline of what occurred here. In the early morning of January 21st, 2024, people that were commuting to work or other locations observed and discovered the body of Miss Shelley Mason lying on the side of Prospect. It was unknown at the time what occurred to Miss Mason, who killed her, and who was involved, but the police were rapidly able to put together an investigation that led to them to be able to identify Miss Waldick as the person that killed Miss Mason. On January 20th, the day of the crash, Miss Waldick had been to a baby shower. She then went to Mays in Ypsilanti with her friends, where she was drinking with her friends. She was texting people that were not present, somebody who was either her friend or her boyfriend. She had texted things to her boyfriend about meeting up with him later. In her text messages to her boyfriend, she indicated that she was out drinking with her friends and that she would be continuing to be drinking with her friends. She referenced to him that she wouldn't feel comfortable driving too far to meet him later, and I apologize for my language, but that she was going to be really hopped up. She did drive instead, though. She drove her car and she killed Miss Mason. After getting home, she didn't stop. She did not call the police, and she left Miss Mason there. After getting home, Miss Waldick saw her roommate's name was Sarah. Now, notably, we now know that Sarah actually drove that same route as Courtney a couple minutes ahead. And Sarah did see Miss Mason alive and walking on the road. And Sarah initially told the police that she saw Miss Mason walking on the shoulder of the road, which is consistent with physical evidence in this case as well. But when Courtney got home, and this is supported by Sarah's statement, as I understand it, as well as from the text messages that followed this, Courtney was quite hysterical. I'm going to call her Courtney. Courtney told Sarah that she had hit someone and that she needed to go back. Courtney and her roommate took over an hour to return to the scene. During this time, Courtney did not call the police. She did not ask for anybody to go out to the scene to help Miss Mason. Instead, she started texting her friends, her family. Her reaction to this was substantial and quite emotional. However, when Courtney came in for her interview with the police, which, mind you, was the Friday following, so she came in for her interview on January 26th. The crash occurred on January 20th. She told the police that she believed that she hit a deer. That this deer had just kind of popped out of nowhere, that she saw it just coming at her. We know from our interview with Sarah, the roommate, that Miss Mason was walking down the road. Sarah saw Miss Mason a couple minutes ahead of Courtney, and that Miss Mason was walking down the road. But what we also know is that Courtney didn't think she hit a deer. Sarah has now told us that Courtney came home and said, "I think I hit someone." Sarah has confirmed for us that there was no mention of a deer. So when Courtney got home thinking that she hit someone without calling the police or stopping to help that someone, she continued to tell her friends and her family what she had done and what stress she was under. She didn't call the police, leaving Miss Mason lying in the snow on the side of Prospect in who knows what condition. And I will say that the evidence in this case bear out that it is possible that if Courtney had just called the police, Miss Mason might still be alive. That's why we have crimes like this. That's why the penalties for crimes like this are so substantial, because Miss Mason may have still been alive and may still be with us right now. Miss Mason was a mother, she was a daughter, and she was a grandmother. And that woman was left on the side of the road without anybody with any help being sent her way. But not only did Courtney not call the police and not attempt to save Miss Mason in any way, what I now know is that Courtney then deleted approximately 150 messages off of her. She deleted those messages that I referenced earlier about her not wanting to drive so far. She deleted a message about her being fucked up. And I will make clear for the record, the message says, I'm going to be fucked up, not that she currently was when she sent it. She deleted a message that said, I wish I would have called 911 immediately. And she also deleted, got to live with it and get my car fixed ASAP. Deleted before her phone was turned over to the police. What she also did when she got home, and I know that defense counsel will argue that this was normal for her behavior, was she parked her vehicle in her garage. That car remained in the garage, and the garage door remained closed, as far as I understand it, with the garage inside. The police subsequently did a search warrant, and it wasn't until they were there with the search warrant that they were then given consent to go into the garage and discover the Jeep. Your Honor, her guidelines as I score them are 19 months, 38 months, as I currently have them scored. My office requested a $100,000 cash surety bond at the time of charging this, and I am again renewing the request. Thank you, Your Honor.
Response.
Thank you, Judge. Obviously, I don't have to tell the court that Ms. Waldick stands here before you innocent until proven guilty. I'm not going to try the case in front of you, but I will address some of the things that were just said. First and foremost, there was an arraignment on January 28th where, as Ms. Hughes indicated, their office requested a $100,000 bond. A record was made. Prosecutor who attended the Zoom arraignment on that Sunday, myself, each made a record, and bond was set at $50,000, 10% with an alcohol tether. It's our argument to the court that that was not an unreasonable bond, nor was it an abuse of discretion. The fact that there's an ongoing investigation or this was charged early, that's not my client's fault. Maybe the prosecutor's office should have waited until the investigation was complete. With that said, Ms. Hughes indicates there was some drinking going on. My client turned herself in as a person of possible interest to the Washtenaw County Sheriff's Department to Detective Webb on January 26th. That date could have been sooner, and the police report indicates could have been sooner, but Detective Webb actually asked her to come in on Friday and not the Thursday beforehand. I appreciate Ms. Hughes said that no evidence that Ms. Waldick was quote unquote fucked up, but that maybe she had said she was going to be. That talks about something in the future. It doesn't mean that she was. The same witness that Ms. Hughes talks about, and I don't think Ms. Hughes would, Sarah, quote unquote, Sarah, who has come forth and said some things, is the same Sarah who said she knew nothing about this originally. So now we have two different stories from Sarah, because originally Sarah said she had no idea what happened on the date in question. Ms. Waldick is now, since the arraignment, been before you twice here on February 22nd for her. She's been compliant with bond the whole 2 months to today's date that she has been on bond since being arraigned, with an alcohol tether the whole time before she was released from jail, with absolutely no issues. So this is the second time before you, but including going to the Sheriff's Department to speak to Detective Webb, she's appeared 3 times. She's not a flight risk. In addition to being on alcohol tether and having no issues, she's also reporting, checking into community corrections weekly. I've heard nothing today regarding any bond violations because I don't think there are any. There's been no change in circumstances as we see it since the date of the arraignment. Ms. Waldick is definitely not a flight risk, and she's not shown that she's a danger to the community in the past 2 months at all. Again, there's been no allegations of that. Judge, the Eighth Amendment of the U.S. Constitution.
At this point, the courtroom wasn't really arguing about whether rent was owed. Both sides were now locked in a dispute over what could have happened if outside assistance programs had stepped in sooner. The judge quickly recognized that the legal issue was becoming overshadowed by hypothetical scenarios. While the tenant believed thousands of dollars in aid could have prevented the debt from growing, the landlord focused on the unpaid rent that remained. The judge's attention shifted toward practical reality. What amount was truly owed, and whether continuing the fight would accomplish anything for either side.
Will appear when her presence is required. Court rules are designed to enforce these principles, Judge, and under these rules, there's a double presumption that a pretrial arrestee will be released without any case bail requirement. And that's stated in 765.6, MCLA 765.6, that in part, a person accused of a criminal offense is entitled to bail. The amount of bail shall not be excessive. Court rules go on to indicate what the money bail should be and what is required, what's considered in terms of setting bond. And those things under subsection F 6.106 say a defendant's prior criminal record. She has none. Defendant's record of appearance and non-appearance or flight to avoid prosecution. She's been at everything. She's actually been at more.
Well, that flight issue also includes concealment of evidence, doesn't it?
And I guess this came up at the bench when we were here on, surprisingly, on 2/28 or 2/20, our last probable cause conference date, 2/22, when neither party had asked to address bond, but you had mentioned it.
Well, counsel, if you want to point at me, I'll tell you exactly what I know about this case. What I know about this case is the warrants came to me. That's how I knew. And that it came to me because I'm in charge of all of these felonies and reviewing every bond that comes through. So that's how it came to me. So if you want to make dispersions against the court, go for it. Let's roll.
I'm not making dispersions. I'm saying the court had asked us to approach and talked about bond.
Because I'm putting everybody on notice where I am. That's why. Go ahead. You want to come at me? Let's do it.
I'm making a record as to.
No, go ahead and make your record. I'm just telling you where I am.
In addition, and obviously we know that search warrants aren't necessarily evidence. I appreciate that you know things or allege things because you were a party to the search warrants. In addition to what I've already indicated in terms of bond, she's not a flight risk. She's appeared at every court appearance. She's gone to the sheriff's department, met with Detective Webb. She consented to a release of and a search of her phone. She doesn't have any shown history of substance abuse or addiction, a mental condition. She's employed gainfully at a local hospital. She's got family members here. She's probably got about 5 family members here. She lives locally. She's got ties to the community. Again, bond is set at protecting the community and a flight risk. I think that what she has shown over the course of the past 2 months is she's neither. I'd ask that bond stay the same. Thank you.
From the people.
Nothing further, Your Honor. Thank you.
The court, in looking at the file and so that the record is clear, counsel came to the bench and the court was apprising counsel that the court had some concerns with the bond that was set. Neither counsel at that time was ready to raise the bond. There were certain things that came to the court's attention that were not in the magistrate's mind nor the magistrate's information at the time of the arraignment. I brought that to counsel's attention, quite frankly, out of fairness to both sides so that it could probably be argued before the court. What was not known, certainly to the magistrate at the time, was that there was this delay. There was information that was provided to the magistrate at the time regarding the defendant turning herself in, which was somewhat confusing as to how that occurred. And I apprise counsel of that. What my initial conclusion or what I saw was based upon what was presented to me prior to that hearing. Additionally, since that time, something that was not available to the magistrate were these text messages which lead also to the defendant's knowledge, which play into this court's mind as to this defendant's danger to the public. Furthermore, there is, in terms of the issue of flight, of concealment of evidence and the like, now the deletions of text messages and other evidence in this case, which have just been alluded to, the deletion of basically evidence, which I think also bears upon the defendant's risk in this case. Also, the likelihood, the court can take into account the likelihood of conviction and other things as it regards to setting a bond. But certainly there is now clearly more information that's available to the court regarding this defendant, the offense that was committed and the like. The court, I will also take into account the fact that I don't have any community corrections violations. I don't have anything along those lines. I do not believe that, given the information now available to the court, that the amount of the bond that was originally set, I do not believe that it is appropriate, and that additional bond would be required in this case. Defendant's bond, Mr. Allen. The defendant's bond in this case will be increased. I think that the amount requested by the people was an appropriate amount. Quite frankly, it was appropriate, but now knowing what I know, I would actually raise it beyond that, but I will not do so. In this case, her bond will be increased from $50,000 cash surety to $100,000 cash surety. Are they, counsel, just for the purposes of anything, are they able to do that right now? Or
we've made arrangements. There's a surety bondsman in the courtroom who can do that. If you can give us 15 to 20 minutes, it'll be taken care of.
She'll be taken back and do that. I think they can do that.
Hold on, sorry guys. We need to arraign her on the information. I apologize. I interrupted all of our proceedings.
Oh, okay. Yes, that's to the circuit court.
We'd waive the reading of the complaint and have the matter set for circuit court pretrial. I asked that she'd stand.
She stands.
The atmosphere changes dramatically as the judge explains why he is reconsidering bond. New information has emerged since the original arraignment, including text messages, allegations of deleted evidence, and details surrounding the defendant's actions after the fatal crash. While the defense emphasizes compliance with release conditions and a lack of criminal history, the court is weighing something different: the risk factors revealed by the expanding investigation. This moment highlights one of the most important principles in pretrial proceedings. Judges can revisit bond decisions when significant new evidence comes to light. These developments are now pushing the court toward a much stricter view of the case, and everyone in the courtroom understands that a major ruling may be only moments away.